Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, we are sometimes triggered by certain buzzwords our clients will say in conversation.
Oh, yeah.
We know that there is potential disaster when we hear these words, and we are immediately on high alert. This season's theme is red flags.
Ooh, yeah. Well, Michael, in 1989...
Ding. Brad, first of all, if I had a nickel for every time I heard you say, back in 1989, and I thought we had an arrangement that we were going to stay away from the 90s and the 80s, just as soon as you started speaking, I should have dinged you.
Okay, moving on. You and I both watched a show from 1989, started in 1989, called
Ding.
Seinfeld.
Very popular show back in the 90s, yes, and they have been featured in our other episodes at different points in time, or mentioned.
Yes.
And so I've been guilty party of that as well.
Yes,
So yes, I'm a big fan, and it's just recently been released on Netflix.
That's right. So our entire new generation gets to watch it. So again, some of my old stuff's coming back in. Michael, have you ever heard of the boy wizard called Harry Potter?
No, Brad, I've never heard of Harry Potter. I've got 5 kids, 2 boys, all ranging in age from 7th grade to young adults. Yes, Brad, I know who Harry Potter is. So, and you also know I need context.
Fair enough. I'm glad you asked for some context. The original title of the Seinfeld show was called Seinfeld Chronicles. This title was shortened due to the confusion that among viewers, many thought the name was too similar to another show called The Marshall Chronicles.
Don't remember that one.
Right. No one's ever heard of it since. Additionally, the Harry Potter book published in America, the very first one, was called Harry Potter and the Sorcerer's Stone, instead of the original title, which was Harry Potter and the Philosopher's Stone. And the American editors thought the title, The Philosopher's Stone, was just too confusing for Americans.
Well, look at the big brain on Brad, making a little play on title changes.
Yeah.
If you figure out how to connect Seinfeld and Harry Potter, then kudos. And speaking of name changes, there's a bunch of companies that have some pretty forgettable original names. Did you know that AOL used to be called Quantum Computer Services?
Yeah.
And that Google used to be called Backrub?
Wait, can I ding a name? Backrub? Backrub sounds like a stalker website or some seedy business that is only open after hours.
Yeah, they got in some more seed capital and decided to change their focus.
Yes.
Starbucks used to be called Starbucks Coffee, Tea, and Spice.
Yeah.
And I'm not kidding here, Brad. Pepsi Cola used to be called Brad's Drink.
Ding. I'm so glad they name changed. Pepsi is not a good name. It's way too inferior of a drink to have such an awesome name.
In other words, Brad's Drink Brad is too good for an inferior quality.
No. Pepsi. Everyone knows that. Well, all right, Michael. When we were preparing for today's original show, we originally had thought this title would be Red Flags, Medical Marketing. But the more we kind of discussed the context of what we will be talking about today, which is really before and after pictures, we had this aha moment. We really need to change the title and focus on a core red flag, which is before and after pictures, thus allowing our audience to be more focused on a red flag inside of marketing.
So we messed up on the name, and you decided just to sugarcoat it by comparing us to Harry Potter and Seinfeld. I like it.
Yes, and the shift of that title is going to launch us. This is going to be one of the greatest podcast episodes ever.
Okay, well, number one, Riley, let's check Brad's Drink over here. I definitely do not think it's Pepsi, well, especially because we know it in Texas that's an inferior drink.
Yes.
I think it might be something a little stronger to give him some liquid confidence. But I like your big dreams, Brad. Brad, let's get started with today's story on before and after pictures.
Perfect. Well, Michael, as we discussed, how before and after pictures, they're basically the lifeblood of any aesthetic practice on other shows.
I'm going to have to give you a ding. This is a context ding.
This is like the second context ding, it seems like today.
Well, that's pretty much one of my things.
Yes,
so
that's what I heard.
So for our listeners out there, they'll know that when we say aesthetic practice, that we're incorporating a ton of different medical practices. Mm-hmm. So let's just reset. Aesthetic practice could be a plastic surgery practice, a dermatology practice, med spas, weight loss centers, wellness centers, hormone replacement centers, or a cosmetic practice. And second, for our audience who may not be following the aesthetic industry, before and after pictures are generally modified or cropped to only show the areas of where the medical services were rendered, and so you can't actually usually know who it is that was the actual patient who received the service.
Correct. And this week we'll discuss two different medical providers and the impact the before and afters had on them, both professionally and personally. Today, the first story starts off in Florida. We have a plastic surgery client that after many years of being part of a bigger practice decided to leave and set up shop on his own. We'll just call him Dr. Potter.
Let me guess. His first name is Harry.
Michael, how did you know? Oh, my gosh. So Dr. Potter's practice was from an area near Orlando, Florida. And for those who don't know, the Wizard World of Harry Potter at Universal Studios is down the road from there.
The Orlando is the straw that stirs Brad's drinks. I know you've read all the Harry Potter books, so how many hours have you spent in Wizard World?
Sadly, none. But you are reminding me it's time to start planning my next vacation. I think Florida is maybe something we should be considering. But let's get back to our story. So Dr. Potter provided notice he was leaving the practice and eventually came and talked to his employer, Dr. Malfoy. And they were able to start figuring out ways to separate. It was mostly amicable, but anytime doctors leave a practice or they separate, there can be some hard feelings. And Dr. Malfoy and the practice was mad that Dr. Potter was leaving, but there's really nothing that Malfoy could do contractually to prevent him from leaving.
I'm proud of you for not talking about how they were issuing spells on each other or anything like that. keeping the story focused. Okay, all right, yeah. I like it. So, doctor divorces or separations can go smoothly or full-on Jerry Springer, much like real-world personal divorces or separations. My question for you is, was there a fight over the non-compete or a fight over the before and after pictures?
Awesome question. Sounds like you've been around this before. No, there was not a fight on either. Dr. Potter left and set up shop and just launched his new website.
Well, so that's a little confusing because our season's theme is red flags, and I'm supposed to ding you, and I'm feeling a very large absence of being able to ding so far. So you have not done a good job so far in picking your story.
Well, Michael, hold on to your magical Quidditch broomstick. Let me get some more fun facts in there. Well, Dr. Potter left and he hired a marketing company. It was recommended by one of his good friends that owned a construction company.
Ding.
And this marketing company had actually never even worked with a plastic surgeon before.
Ding.
When the marketing company started to set up Dr. Potter's website, they pulled all the before and after pictures off Dr. Malfoy's website.
Ding.
And never determined which physician actually provided the medical services.
Ding.
The marketing company basically then launched the website with the best before and after pictures that the marketing company selected.
Ding again. Brad, you've totally redeemed yourself.
Yes. Thank you. I appreciate that. So, no surprise to anyone in the aesthetic industry, Dr. Malfoy and his partners were fuming when they saw this new website. Dr. Malfoy sent some death spells towards Dr. Potter.
Ding.
A cease and desist letter to Dr. Potter.
Ding.
And Dr. Malfoy filed a complaint for unethical behavior to a national plastic surgery organization, which they both happen to be members of.
Ding.
This opened up an investigation of Dr. Potter for violating the organizational rules.
Wow, that escalated quickly.
Yes.
Well, let's pause. Tell me what the second story was.
All right. So our second story, we have a nurse practitioner, George Costanza, working for a plastic surgeon, Dr. Cosmo Kramer, in New York City.
Seinfeld. Nice.
Thank you. So Costanza helped run Dr. Kramer's non-invasive medical services, but Costanza wanted to start his own med spa. Dr. Kramer started hearing these rumors from patients and staff that Costanza was soliciting Dr. Kramer's patients.
Ding.
And ended up firing Costanza.
Whoa. Okay, well, what happened next?
Well, Costanza had already had cell phone numbers of many of the patients on his cell phone.
Ding.
And left and started his own practice. While working for Dr. Kramer, Costanza had already started to download these before and after pictures.
Ding.
And Costanza started using these before and after pictures on all his social media feeds.
Ding.
Dr. Kramer's team, again, saw these pictures, many who Costanza had never treated.
Ding.
Following suit, Dr. Kramer said, you know what, we're sending another cease and desist letter.
Another death spell. Even
another
in
death
Seinfeld.
spell, yes. But
Ding.
this is Seinfeld, so
Yeah.
it had to be something different, like no soup for you.
Okay. Ding.
And reported Costanza to the nursing board.
Ding. Wow. Okay, well, Brad, you managed to weave two stories through and around Harry Potter and Seinfeld, and with the commonality of some before and after picture problems. And look forward to going into commercial and talking on the other side about the different dings and red flags from these stories and breaking it down from a legal perspective.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd. Before we went to commercial break, I just finished two stories coming from two different, with lots of red flags, one from the world of Harry Potter, one from the world of Seinfeld. And let's really start with the very first story as to why you kept dinging me, because at first you were afraid there would be no dings, and then we found, as you heard, lots of dings. So when I said that Dr. Harry Potter, had hired a marketing company, why did you ding me?
Well, you didn't just say you hired a marketing company.
You remember.
Yes. You told me he hired a marketing company with one of his buddies that did a different line of work. I don't remember exactly what that line of work was. Construction.
Yeah.
Yep. There you go. I was listening, Brad.
You were.
So let's just start with this acknowledgement, because there's nothing – it can paint the picture that marketing people are – marketing websites, et cetera, have some – sinister motive to it. And there's not that at all. A marketing company's perspective is to do the job you hired them for, which is to get leads.
Yep.
And that's their world. And someone that's doing this in another industry has no reason to believe that the medical world is as upside down as it is from a compliance perspective, where what is up is actually down. Things that are intuitive business tactics are often problematic in healthcare. Mm-hmm. And so the ding is that, hey, you're putting together a website that's going to be creating leads for patients. And we've talked about this in other episodes. Yep. that their doctors are regulated by their different medical boards and the different states' medical boards on marketing. And then to take it even a step further, there's some extra sensitivities with aesthetic marketing, because you are really trying to get someone to electively choose to get a procedure done and go to you to do it. And so it has that consumer feel to needing to get them in. It makes you more tempted to push boundaries to create leads. And when you're putting before and after pictures and stuff like that on, you're putting sensitive body parts on. And so if you're not aware of the regulatory landscape, there can be problems.
Yeah.
Thus the ding.
Yeah. And I think on your point, just for our audience as a reminder, we've talked about this in other episodes, is in most states, the theme of the enforcement is when you are using medical marketing, it can't be false, misleading, or deceptive. And, when you really think about those before and after pictures, if they're not your before and after pictures and you're just using models or something else, that can be considered false, deceptive, and misleading. And in this case, with the construction company, they can make a really pretty website with lots of SEO, but they had no idea about these limitations in place. So good ding. I'll give you credit for that.
Okay.
All right. Additionally, in our Harry Potter story, you ding me when basically the marketing company pulled all the before and after pictures of Dr. Malfoy's website and selected the before and after pictures. Why was that?
Well, one you just touched on. There's kind of three different areas to think about. One's what you just said, which is that this false and deceptive. If you're holding out a patient as something that is representative of your work and you didn't do it, you can get in trouble for that.
Yep.
Going back to the model thing. So if another doctor operated on the patient, then that's a big no-no. The second thing, we haven't talked as much about this, is kind of a contractual intellectual property component. And, before and after pictures are very valuable to a practice. And typically when you are part of a practice, all the IP is owned by the practice. And so when a departing, whether it's a partner or an employee, leave, if they take those things, you ding it to say, okay, did they just take something that they shouldn't have, and are they going to get in big trouble for this? So you have potential exposure in this case with your ex-partners for taking intellectual property that is not your own. And then, the final thing is a more of a regulatory HIPAA risk, and that is now you have a doctor taking before and after pictures and plucking them onto this brand new website, and the patient most likely did not sign a consent for these before and afters to go to Dr. Harry Potter's new business, and so you have a HIPAA breach.
Yeah, and we'll talk. I think maybe I'll address. You said two big issues with HIPAA and IP, but I want to stick with this story before I would like to follow up on two things you said about that. But I want to keep going with this one because this is unique compared to our next story, which I agree with everything you said as far as the making sure when someone is, if it's a physician and you have a contract, what does your contract say? Do you have the proper consents of the patients to allow you to utilize those? All those are other important elements, no matter what, in your side of your practice. So let's keep moving through this story, though, and this one's unique because this one when Dr. Malfoy was upset, and not only did he send a cease and desist letter, the death spell as I called it, but he also reported Dr. Potter to this National Plastic Surgery Organization. Maybe you can maybe first just address. You and I use this term all the time, but what the heck is a cease and desist letter?
I mean, the easiest way to think of it is what my discussion a moment ago about the IP rights, that the cease and desist letter is a usual first consequence of you breaking that. In other words, you've taken something you shouldn't have taken, and it's akin to a demand letter, basically from the owner of those rights saying stop immediately or you're going to get sued. Mm-hmm. And so it is a shot across the bow, aggressive action that is the fruit of him having unknowingly taken a bunch of pictures and put them on his website.
So it's not a spell that kills people.
It doesn't actually kill people, nor is it a spell.
Okay.
Brad, yeah. So make sure we don't tell clients that.
Yes.
Next time. Okay.
Got it.
And then you asked about these national organizations, and in plastic surgery, for example, there's ASPS, ASAPS, and there's other organizations, and they have their own rules in play, and so
typically like the code of ethics.
Yes, and so you as a member of one of these organizations have to follow the code of ethics, and surprise, surprise. a lot of them have rules that kind of track medical board rules. So false and deceptive advertising and taking things from your partner and posting them as your own are the types of things that they frown upon.
Yeah. And if I remember correctly, in this particular matter, it was as you were, they were saying, look, you're infringing on, as you said, the intellectual property. You're misappropriating my property, and the ramification of this, unlike a medical board investigation where you lose your license, you could be kicked out of the society, which then impacts you with the other doctors you work with, your ability to show up and speak or attend these conferences. So it sounds silly to maybe an outside layperson, but it's a big deal if you are kicked out of these well-known societies.
Yeah, you kind of become an outcast
Right.
in your world. It's a much bigger deal than we could possibly depict. Just talking about it.
Yeah, and I think one of the things that when we have these separations and these providers, you solely treat a certain patients or whatever it ends up being, who owns these before and after pictures always get lost in the shuffle. And sometimes it's because it's hard to think through because maybe you did touch that patient or maybe you did a little bit of the treatment on them. But that's the problem that I think a lot of people don't realize is that it's typically the physician who's treating it is that the before and after pictures are theirs. And I think I mentioned this earlier, which is if you have an employment agreement and your employment agreement says that the facility or the practice owns all of them, it's really hard for you to walk away and say, these are my before and after pictures. And a lot of those employment agreements do say that. And so one of the things I think we always recommend is if you are a provider and you plan to want to be able to utilize these before and after pictures, have those hard conversations up front with your employer to say, hey, I would like to be able to use these on social media or use them if I ever leave or use them to get my board certification. The other piece is that it's not just up to you and the employer. The patients in their consents, as we said earlier, they also have to be able to allow you to leave and continue to utilize those same ones. So it's a bigger picture, a lot of things just from happening on there. So let's switch to our next story, Michael. And remember in this one, we have George Costanza and Dr. Kramer. And in this one, you did hit me several dings again. So some of the facts were similar, so that your answers would be the same. But one that you hit me with is when I said, well, that Costanza had all the cell phone numbers or a lot of the cell phone numbers of Dr. Kramer's patients. Why'd you ding me on this one?
Yeah, it is. You're right. Everything kind of weaves together in both of these stories as to your issues. But here, kind of a different spin is that owning or having those cell phone numbers and the names is confidential information. And in fact, that is, again, an asset of the practice that you can't just take it, going back to, the whole IP discussion we had earlier. And again, I mentioned HIPAA once earlier, and that is that it's not just between the practice and, in this case, Costanza, but the patient has a say in all of this and a right and a voice. And so there are HIPAA implications that come into play when you take, patient name and cell phone and stick it into your cell phone. So talk a little bit, Brad, about HIPAA. Yeah,
and we've said HIPAA a couple of times. For those who don't know, it stands for the Health Insurance Portability and Accountability Act.
Ding. Sorry. You're already putting me to sleep, so that was a sleep ding.
All right. Stay with me. I'll keep it basic. HIPAA is the standard for controlling how patients' health information must be disclosed. Its primary goal is to ensure that individuals' health information remains confidential, but still allow the flow of health information to be provided between your providers and other healthcare providers, and obviously looking out for the well-being of the patient. Now, sounds awesome, right? As we mentioned in other shows, HIPAA may not directly apply to many practices in the aesthetic market, but many courts have established that HIPAA is the standard of care that you have to follow for patient privacy. Providers and practices unfortunately have been held to be negligent for not following the standard. Michael, but no more HIPAA talk.
Yes, please stop, Brad.
You're welcome. On the second story, you also dinged me when I started saying that Costanza, while working there, started downloading these before and after pictures And then he started using it on the social media. And this kind of, again, somewhat tracks what we talked about earlier. But you did ding me, so why did you ding me since even though he never treated these patients?
Well, let's kind of flip it around a little bit and talk about all this from the practice's perspective. And we've talked about how this is confidential information, intellectual property in both stories. And, the question starts to become, well, what controls did the practice have in place to protect this? And so there's one level of, well, you may not have gotten your stuff stolen if you had been doing something to protect it, which is kind of practical and obvious.
Yeah.
But then there's a second thing, which is you can actually be hurt legally in an argument if you're trying to make the position that you have this information as confidential information, but you don't do anything to treat it that way. Yeah. In other words, it's just anybody that works in an office can flip open the computer and get access to all this stuff. The court's going to say, you're calling it confidential, but it's not really treated accordingly. And so you actually create a secondary risk where you could actually lose your argument, with the court over that issue.
Yeah, and we probably could spend at least 15 minutes alone talking about intellectual property and confidentiality, Pete. But obviously the point of this is to educate people and not put them to sleep. So we want them to stay awake. I've already done HIPAA talk, so let's just keep moving forward. But for our audience to understand, the intellectual property laws do exist. They absolutely can impact medical practices and medical providers. Most practices, just in general, have the right to all their intellectual property, which includes a lot of times before and after pictures. So you're not always freely able to just use it from one place to the next.
Okay. Well, tell us what happened with both of these stories.
All right. Well, doctors Potter and Malfoy, they were eventually able to work everything out. Dr. Potter, Harry, had to fire his marketing company and basically just take his website down to remove all the offending pictures. The society eventually dismissed the complaint, but it made the rounds that was going on, so people kind of knew about it. So it wasn't exactly private, but a lot of people might think, oh, that was a good result, but not really, because he delayed the launch of his practice. It led to him having to take down his website, basically develop a whole new website. And as mentioned, before, the before and after pictures are key to aesthetic, or in this case, the plastic surgeon's practice, because it really demonstrates when someone's looking for you how good or bad you are at it.
Yeah, true stuff. And, not to mention the egg on his face that he got with, the embarrassing having to fix the mistake that his, construction marketing company had. Well, tell me about Costanza and Dr. Kramer story.
Yeah. So again, a lot of major red flags in the story. Costanza did take down Dr. Kramer's pictures from the social media website. Costanza is still in hot water right now. Costanza may have borrowed other images for his social media from other medical practices all across the country.
Ding.
And the nursing board is now investigating Costanza for practicing without a collaborating physician.
Ding. Brad, we're supposed to be cleaning it up and wrapping it up at the end and not be adding some extra dings to the story. This is maybe should have been a dumpster fire season.
Well, you did ask me what's happening, so that's what's happening. All right, Michael, these stories, remind me of how tricky before and after pictures can be. During the season 3, if you remember, we did have a show called When Private Parts Create Privacy Problems. And on that show, we as you talked about earlier, we talked about how easy it is to breach someone's privacy. This show really was highlighting and addressing how hard it is to make sure who owns the before and after pictures, who can use them, and on what platform. So hopefully our audience will see how tricky utilizing these images can be for any provider or practice, and that those providers and practices that are in the aesthetic industry, they need to focus on this issue, follow the rules and regulations, and make sure that they're in a safer position so they won't be our next red flag story. Michael, final thoughts.
Yeah, it's kind of dovetails off that. Kind of, think before you act is the biggie here. I mean, what bigger lesson could Pepsi have learned than to name their drink after you to start with? And, what a bomb that was. So do that, or, go get a construction company to build your website and steal a bunch of photos that you don't own. All bad ideas.
All bad ideas. All right, Michael. Well, guess what? We are back next Wednesday with an all-new show, Red Flags. Non-competes are not enforceable. Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.